established by the Constitution and the law and nothing else. I have told many of my employees, make sure you search for the right answer, not a convenient answer, and certainly not an agenda-driven answer. My office pursues justice for victims, for the community at large, and we demand of each other and to all who come into contact with us equal treatment under the law, the Constitution, as well as the statutory scheme. We are mindful of our professional responsibilities under the rules of professional conduct, and we do not allow any improper motive to affect prosecution. But it's even broader than that. Cases are not sought by my office. They are brought to my office by the local law enforcement. We work with several municipal police departments, which include Liberty Lake, Cheney, Airway Heights, the City of Spokane, as well as the Spokane County Sheriff's Office and the Washington State Patrol. But that's not all. In addition, we work with federal partners, DEA, ATF, sometimes the FBI. Certainly, we work frequently with the United States Attorney's Office. Why do I bring that up? Because during the 7 years plus now that I've been the elected county prosecutor, we have worked with these agencies daily, if not weekly or monthly, but frequently. And during all that time, in which now it's being alleged that because of some comments that were made by my wife, that somehow this has become endemic in the process of the local criminal justice system. I refute that claim. I refute that insinuation, and it is baseless and without evidence. The reason I bring these other agencies up is because they work with us every day. And never once has one of those police chiefs come to me and said, Larry, what's going on in your office? It appears to me that there may be improper motive in your prosecution standards. I've never heard that. They're not bashful. They're not heads of their various law enforcement agencies for nothing. Spokane County Sheriff's Office has never come to me and said words to that effect. Neither have any of our federal partners. Neither Spokane Police as well. If this insinuation is true, and someone were to want to believe that these views are practiced in this office, then all those other agencies must be complicit because they haven't said anything. They haven't raised it. They haven't raised it to me. They haven't raised it to you. They filed no bar complaints, no complaints with the judges. So let's talk about the judges for a moment. Every case that comes in has been found to have probable cause by first the law enforcement officer. Very often, before a prosecutor even touches the case goes before a judge. A judge then reviews whether or not there's probable cause. Most times they agree with law enforcement, and other times they don't. But a prosecutor hasn't touched it yet. When we get the referral from law enforcement, we review it, but not just for probable cause. RCW 994A411, funny I should mention statutes, guides the analysis for a prosecuting attorney when they're deciding whether or not to file a charge. Sometimes probable cause is all we have, but we have to look at more than that. The statute demands that we look at the admissible evidence. So we have to make a determination initially about whether or not the police gathered their evidence in accordance with constitutional and statutory standards. And then after that, we take a look at whether or not the admissible evidence what would that look like in light of the most plausible, reasonable defense that would be raised under that evidence? And then after we've done that analysis, we have to ask ourselves whether all those things considered, the remaining evidence would justify a finding of guilt by a reasonable fact finder, in most cases, a jury trial. Sometimes the jury gets waived and it's a bench trial, but that is far more rare. So why do I bring that up? Well, there's been allegations in the media recently about the bond system. Now, when somebody goes before the court, the judge reviews CRR 3.2, or in the case of the district court, CRR LJ 3.2, Court of Limited Jurisdiction, and makes a determination, first of all, whether there's probable cause, and then looks at factors contained within the court rule to determine whether or not somebody is a risk of flight, or they're a risk to interfere with the administration of justice, intimidate witnesses, or possibly to commit another or a violent crime. Judges make that decision. Prosecutors make bond arguments, but they don't set bond. Defense lawyers make bond arguments, but they don't set bond. Judges do that. There are multiple steps throughout the pendency of a criminal charge that will get additional judicial review. Motions are brought to suppress evidence, again, based on shortcomings in search warrants or in the gathering of the evidence by the police. These all go, again, before a judge. And speaking of judges, in the 7 years I've been a prosecutor, I have not heard a complaint from a judge that we have acted improperly, that we act without the proper motives, that something insidious or something evil has snuck in. I've not heard that. Judges aren't bashful either, you know that. They're quoted in the paper regularly. But that allegation has never been there. And I can tell you flat out, I don't live that way. And I don't practice that way. And I wouldn't tolerate it in my office. And they wouldn't tolerate being there if we were doing that. Because everybody knows what the rules are. They're not hidden. They're not vague. So that allegation is simply untrue. It is baseless. Now, I want to tell you how much pain this has caused. My employees aren't sure what's going to happen next. They're not sure whether they're doing the right or the wrong and how this is all going to turn out. I tell them, hold their heads up high because you're doing the right things. And that these allegations are false and they know it and we know it. And now it's time for you to know it. And I'm putting it out to the community to know it as well. But the pain that is still in the office is measurable. The pain that has been within me is measurable. And I know the pain that's been inflicted in this community is measurable. And I apologize for that. But I can tell you that as your county prosecutor, I will continue to prosecute in the manner in which we have. Strong, just, ethical, and only based on the motives that are required by the law. I wouldn't have it any other way, and every law enforcement agency here wouldn't have it any other way. The judges wouldn't have it any other way. And if somebody isn't doing it right, somebody would have seen it, reported it. And that's not the case. This office operates according to all constitutional, statutory, and ethical standards. No matter what my wife's views are, I don't care what anybody else's views are. If you don't want to prosecute in accordance with the rules, then I wouldn't want you working for us. The community deserves that, and they get that, and they will continue to get that. Innuendo is not evidence. In the world that we live in, everything revolves around what you can prove. You may have seen the old movie, A Few Good Men. Doesn't matter what I believe, it only matters what I can prove. And there is no proof of the innuendo. The allegations being made against this office, it is hurtful, it is painful, it is insulting, and it hurt my people. And I care about them. I've taken on many, many steps since I've been elected to make it a better place to work, to make it more people-friendly than it used to be under previous administrations. And how they feel is a huge consequence to me, and I care, and I'm insulted. So the whole system essentially is being indicted by innuendo. One set of views becomes Larry's set of views. That set of views now is the rule of the day in the office, and apparently, according to the way it would have to be, all 150 plus employees are okay with that. Well, I can tell you, they wouldn't be okay with that. Because among other things, I teach them to make sure that they're not okay with that. I want to talk briefly about disparities in the jail. There was an article recently, I believe in the Spokesman, Mr. Haskell, and possibly in a communication from SCAR, which is the Spokane Citizens Against Racism, that Larry Haskell is responsible for the disparities in the Spokane County Jail. And when I say disparities, I'm sorry, that's shorthand. Disparities, I apologize. And the fact of the matter is, I think I've demonstrated that people that are in jail are there because a judge made a decision that they should either pay a bond or that they would stay in the county jail. And that analysis of the disparities is really only a number until you dig deeper. People get put into the jail for a number of reasons. Some people are there because they failed to attend a court hearing. Some people are there because they were released or they paid the bond and they got out and they committed a new crime. Other people get arrested on federal charges and they're on federal holds. Other persons are on Department of Corrections hold. If you're on community custody and you commit a violation and they have an administrative hearing in the Department of Corrections, then they can put you in for a sanction for whatever conduct that was in violation of your terms of release. You notice I mentioned a lot of things, but I didn't mention race. I didn't mention ethnicity, because we don't practice that way, and never will, and never have. So I want to issue a pledge, and I would ask anybody in leadership positions or members of community groups who are against racism to sign a pledge. A pledge that at no time in any discussion about the criminal justice system, its shortcomings, its weaknesses, its strengths, or what we need to do to change it to be better, that at no time will anybody use any language, written, oral, or otherwise, disparaging somebody by a stereotype or by race. And in fact, the sheriff could note, and others, that recently when the restructured Spokane Regional Law and Justice Council met for the first time back in November, I believe it was the 10th, that each of us were requested by the chair, which is Sheriff Knizovich, to put down the 3 most important issues that you think the council, as reconstituted, should address. And it is a matter of record that one of the things that I said is that we should, this was back in November, that we should treat each other with respect and dignity that we would want others to treat us. That we would not resort to stereotypes or racial slurs of any kind. That was one of the 3 things that I put down. That we be respectful and that the dialogue be respectful. We're going to disagree, but we got to be respectful while we do it. I tell my lawyers the same thing when they go to court. It is not a personal battle between you and the defense lawyer. They have a job to do, we have a job to do. Do your job. If you have questions about what that is, I'll help you out. That's what I'm here for. And along with the allegation of racism, I would also welcome any independent investigation or audit of what we do in our office and how we do it. Bring it. We can withstand the light of day. We can withstand the light of an investigation because we don't practice that way. And we never have. I did want to go back briefly to the disparities in the jail. Those disparities that we have right now, the numbers, are, the allegation is Larry, that's all, Larry. But the fact of the matter is those disparities have been roughly the same numbers for the last 10, 12 years. I took office in 2015, and the numbers were the same since approximately 2009. So I'm not responsible for the disparities, but I am willing to have a discussion about them and drill down and look at who's in the jail for what reasons, and if they committed a violent crime or not, and whether or not a judge found probable cause and set a bond, and whether or not they have a history, because there's a statute in the state of Washington, 994A 340, that says prosecuting standards and sentencing guidelines are to be applied equally across the state without respect to any other factors than the crime at issue and the history of the defendant. Nothing else. So those prosecuting standards, that's us. Do we have a statute? Yes. Constitutional? Yes. Court rules? Yes. Case law? Yes. The prosecution is not unfettered. It is tethered to those documents and those principles, and we apply them every day in our work. So that concludes my remarks, and we got about 5 minutes or so. So yes, Mr. Walters.
Has there ever been any grievances or complaints filed with the state bar that involved your wife's comments that have been made?
Not that have reached me.
Not that have reached you.
Oh, wait a minute. No, wait. Way back about 10 years ago, yeah, I'll tell you about that. So there was a bar complaint that was filed during a trial, and I believe it was the Shelley Stark trial. Is that the one you're referring to? Okay. So in 2009, along with Mark Cipolla, I tried a case involving the murder of Dale Stark by his wife, Shelley Stark. And my wife attended court, as did a number of people. And of course, it's an open courtroom, and the rule is that if it happens in a courtroom and the court's not closed by the court, and they have to make a specific finding in order to be able to do that, it's a process. But the court was open, and then what happened after that was my wife went and blogged on a blog that she was on at the time, and this was in '09, boy. In any case, I wasn't elected. But there was a bar complaint filed by Ms. Stark and then eventually one of her family members. It went up, and we had to respond. And essentially, what the Bar Association found in that, they eventually dismissed the complaint. And what they found was that I am not legally responsible for nor accountable for whatever my wife says, for one thing. Now, if it's an employee, that's different because you have this employment relationship, and if you're a supervisor, or in my case, as the elected, I'm ultimately responsible for the conduct of each and every one of them. But they found that I wasn't accountable for that legally. And they also pointed out that if it happens in an open courtroom, you know this as the media better than anybody, right? Is if you go out or live stream it, if you got the permission from the court, or you run right out and put it in the newswire, then what's the complaint? There isn't one. It's an open court. It's in the public record already. And even prosecutors, during the pendency of a case, we have a lot of rules that we can't talk about. And I usually, when I meet a new media person, I give them these little cards that we have that explain the brief of the rule of the RPCs, what we can talk about and what we can't. And one of the things that we do get to talk about is if it happened in open court, if it's in the public record or public domain already. So that's, to my memory now, the best that I can give you. They did appeal. And apparently one of Ms. Stark's sisters, of which she had two that were involved in that trial, claimed in an affidavit that I had walked into court one day, threw a briefcase down and said, "Everyone, cigars for everyone." I blogged it today, which was patently false, and the bar eventually dismissed the complaint entirely.
Is are any of the comments that have been made, do you believe any of the comments that have been made by your wife are racist?
I believe the comments are racist, absolutely. And as I said, they're reprehensible, and they've caused a lot of pain. And I humbly apologize for them.
How did you, this has been, a dozen years that this has been, how have you handled it with your wife? Have you tried to persuade her that she's wrong?
We have had many discussions. I'm not going to enter publicly the discussion we have, but I speak to my wife on a regular basis regarding certain things that you're talking about. Yes, ma'am.
So I think a lot of the things that you mentioned are, operations of the court, but, in your role as a prosecutor, you do have the ability to advocate for certain programs in criminal justice in this area. One of them, for example, is supervised release, which potentially could address disparities in the jail. With this coming out, is this potential to rethink, your issues with that program, because it could address disparities?
Sure. Yeah, and so one of the other jobs that we have, I have an entire civil side, and the civil lawyers that I have, along with information flowing back and forth with us, we weigh risk to the county. We're the county's representatives for the risk manager, as well as the Board of County Commissioners. And when there is potential risk, it is our duty to advise the agencies that a given program might contain some risk. But the program that you're talking about, the Board of County Commissioners has reassessed it. And they have decided that they intend to implement a program similar to that, but possibly using county resources as opposed to private. But here's another thing, and this got lost in the shuffle of these discussions, and that is the judges ultimately can do whatever they want to do, within their discretion. Each side can appeal, or if they feel that it's so patently wrong that it's abuse of discretion. But the judges could order it, and if we felt that it was abuse of discretion, we could appeal it. But the reason that we came out initially opposed to it was because, and even the risk manager, and I mentioned this the other day at the SRLJC meeting, I said even the risk manager was opposed to it, because if the county gets sued Okay, if the amount is roughly $300,000, I believe it was $281,000 that the MacArthur Foundation had given the county for that. If the county gets sued and loses, $300,000 is potentially a drop in the bucket to what the county would have to shell out if we misassessed or simply missed the risk entirely. So it's part of a duty. It's not obstructionist. I have a list at my office of all of the reform programs that have been proposed under MacArthur that we have supported. And again, we still, it's our duty to the county, it's our duty to the public to measure risk. And we do that in conjunction with the statutes and the case law and analyzing that against the program itself. But I believe that supported release will be a reality in the near future. And again, a judge could do it anytime they wanted to.
Do you believe that your wife is racist?
I believe that her comments were racist. I have known that woman for 30 years, and I do not believe she is a racist. But what she wrote was racist.
How does this happen to somebody that you love?
You know, Mr. Walters, you want me to expose things that just aren't for public knowledge. I have had many conversations with my wife regarding this stuff, and I have condemned it publicly, and I have called it reprehensible, and I have told you that the comments themselves were racist, and I can understand how somebody who doesn't know her would say, oh, that's a racist. But I've got 30 years on top of those posts that I've known her since she was in her late 20s. So I can tell you that she is not a racist, but the comments were racist.
If somebody from if a deputy prosecutor or somebody in your office made some of those comments, how would you have handled it?
If a deputy prosecutor made comments like that,
Yes.
well, now that legal relationship changes now, doesn't it?
Yes.
And they would be summarily terminated. They would, however, they would get due process, right? We still got to prove that they did it. But once an allegation like that was proved, they would be terminated from the office. But it's not a marital relationship. It's an employment relationship, and that's how there's a huge difference. Is there anyone else with a question? I know Mr. Walters has dominated. We got one more question. Sir.
You highlighted the diversity of your office. Forgive me if this is readily available, but is there a report detailing and quantifying the diversity within your office? And if not, would you be willing to commission one?
Well, you know, I don't know. I mean, the information I believe is available through Human Resources, but off the top of my head, okay. So please follow up with the office on that. And we'll get you that information. If it's something that we can make public, we will do so. Okay, so that's about all the time that we have. I want to again thank you very much for your time and being here. I hope that I put some light on this subject that, light and truth that simply wasn't in the dialogue prior to this moment. Thank you very much. I'll leave your equipment. Thank you.